Let's get this through real quick. So let's just concentrate on this so we can get out of it early. So let's say that you've shown that a clear contract is formed. Your essential elements are there. The next part of the question is then, what are the terms of that agreement? So what are the parties signing themselves up for, really? What are their obligations? What are their promises? Now, terms in a contract can be either express, meaning that they're explicitly written or stated, or they can be implied. Implied terms are a lot harder to identify because they're not necessarily there. You can't read them, you haven't said them, but the courts will imply them in. I'll explain how they do that throughout this lecture. The other important thing is noting the difference between a representation and a term, which is legally binding. So a representation might be statements. Sorry guys. Statements that parties make during the negotiation phases, but they don't intend them to be legally binding. And I'll explain how we identify the difference between a statement that someone said that's not legally binding versus a term of the contract. And once we determine whether it's a term, we then look at the different types, noting that a lesser term will change the remedies that are available to individuals. I'll explain that. So I've got a very basic example of a contract and its contents. Parties will disagree about terms. Sorry, girls. Sorry, so we can keep moving. So parties may disagree about what terms are. So we've got a delivery here. Someone's thought that they were going to get free delivery. Why have I been charged for delivery? I thought this was free. Now, this individual is saying, well, free delivery was only discussed as part of our pre-contractual negotiations. It never formed part of the contract. We've got someone saying, well, you promised. So maybe promissory estoppel. And then this person saying, well, you should have put it in the contract. Just a representation. Then all of a sudden you're in court. So this is what we're trying to distill and understand. The rights and responsibilities of the parties. And to do this, we look at how important those terms are. Have the parties acted in reliance of those terms? Are they critical? And are they incorrect? Excellent. So firstly, the first thing you'll need to do is identify whether the terms in the agreement are a representation or a term. So a representation is not part of the contract, and thus it's not legally binding. Noting that although misrepresentations are not legally binding, we talk about the concept of misrepresentation next week. So if you deliberately misrepresent something, you could be liable for that misrepresentation. Let's say you've got a paddock that fits 10,000 sheep, and you know that you have someone that's buying it that wants to fit 15,000 sheep. And you tell that person it fits 15,000 sheep even though you know it doesn't. There we've got a fraudulent activity and a fraudulent misrepresentation that the court would provide remedies for. But generally speaking, a representation is not legally binding. So how do we distinguish? We look at these things. First one is a puff. Now, puff is a statement that's made before the contract's formed that no reasonable person would believe. Who has bought toothpaste that will make your teeth whiter than white? Who's had the world's best coffee? Were you disappointed at any stage? Was it the world's best coffee? You can see how those statements would not be enforceable because they're just puff. No reasonable person would go, all right, this shop, we're in Melbourne, so there's a lot of coffee shops. This particular shop has the best coffee. Plus it's subjective. This is the most awesome car. So we see this in ads, but puffs are not binding. They're representations. Other representations such as non-contractual statements of fact. I don't like this example, but we've got rubbish is collected on Tuesdays. Could be a representation. One that's important for us to note is opinions are generally not terms. So I think that it will travel 25 kilometres. I know, maybe buying a moped. I believe that it may fit 10,000 sheep. Having these opinions are not contractually binding. Then lastly, we've got terms which are binding. And we use case law to determine which category words of a contract or pre-contractual statements fall within. So here's our famous coffee. An example of puffery. And in fact, the Carlisle and Carbolic Smokeball case tried to argue that their advertisement was puff. No reasonable person should ever believe that inhaling vapours, carbolic acid vapours, would have prevented them from contracting influenza. But because their advertisement was so precise, the court actually overrode that. So you've got these conversations occurring before the contract's formed at this stage. Firstly, look at, are they false or misleading? That's what we look at next week. Did they induce you to enter the contract? If false, and this is misrepresentation, you can sue for that. If they're not false, they're correct representations, they're not enforceable, so you can't sue. Just remember that. You need to identify whether it's a representation or a term. So it depends on what you can or can't do. And here's what's important. The factors that we use to determine if a term is a term or a representation. So the first one is the language of the statement. Is it a promise or a guarantee? Versus an estimate or a I think. Secondly, the timing of the statement matters. The closer the statement is to the formation of the contract, the more likely it is to be a term. Content and importance of the statement is also important. If it's a very significant statement, and I'll go through these cases, it's more likely to be a term. Relative knowledge and expertise of the parties. The more expertise an individual has, the more likely that their statements will be a term of contract. On the contrary, I don't know much about cars. My statements about the engine of a car would probably be more likely to be a representation because I have no expertise in that area. Did the parties reduce it to writing? When it's consolidated into writing, and this is based on the parole evidence rule, it means that any previous verbal statements are omitted from the contract. So they take the written contract to be the entire document. So if you've got a reduction into writing, the statements made pre-contractual are generally not part of the terms. And we'll talk about the parole evidence rule as we go. So let's just look at the cases that we use. So as you go through the formulation, use these as your balancing point. What was the language of the statement? When was it made? Was it important? And what was the expertise of the parties? Use them, mix them together, and then come out with a conclusion based on the probability that it's more likely to be a term or more likely to be a representation. And you can use these cases as the basis for your arguments. So JJ Savage and Blakeney is an opinion case. And here we've got Blakeney entering into a contract to purchase a motor cruiser boat from JJ Savage. Now JJ Savage is a boat builder in Williamstown. And Blakeney had very specific specifications that he wanted this boat to be built at. And in particular, he wanted the boat to be able to maintain a certain speed. So So maybe 25 knots. Now, J.J. Savage don't actually manufacture engines. They just build the boat. And what they've done is they've provided Blakeney with a list of 3 engines they would recommend. And they've said that they estimate that if it was fitted with these particular engines, that it would maintain a speed of 15 miles per hour as required. Notice the word estimated. There was also no reference to speed in the written contract, remembering the written contract would take precedent. The boat did not go 15 miles and Blakeney sued for breach of that contract. Because of the language of the statement, it was taken to be a representation. They represented that it would go 15 miles. It was not contractually binding that it didn't. So that's a good case for you to use. So it's having a recommendation rather than a promise. Harling and Eddy is the case you use for timing of the statement. Harling and Eddy, we have this sickly cow that's being sold at an auction. And no one's bidding on this cow because it doesn't look well. Its bones are sticking out and no one wants to bid on it. So the person selling the cow goes, why is no one bidding? And they make a statement that there's nothing wrong with the cow. It's actually quite healthy. So the plaintiff Harling's gone and bidded. That bid's been accepted during the auction. But the cow or the heifer actually had tuberculosis and died shortly after the contract was entered into. The question is whether that statement forms part of the contract or not. And the fact that it occurred right before the contract was formed, we're at an auction, the timing of the statement was so close in proximity that this is more likely to be a term rather than a representation. So just before, you've got a term. Also noting that it's what really induced this person to bid on the heifer, and that's what resulted in a loss for them. Vend and Eschert is about the importance. Now this purchaser is buying this house. They're signing the contract and then they ask the vendor for assurance that the house is free from termites. Sometime after the purchase, they've moved in and realised that the house actually has termites. Has anyone experienced a house with termites? Yeah? It's not good, it's damage. Significant costs involved in this. Anyway, massive structural damage, needs repairs. The purchaser then tries to sue, saying that that assurance that the house was free of termites was a term, not a representation. Because of the significance of the statement and the damage, it was held to be a term. I should also note that the timing of this assurance was just prior to the contract, or just after. Just prior, sorry. So you've got that issue as well. But the more significant the statement, the more likely it will be a term of that contract. Relative knowledge and expertise. Who can tell the difference? Who knows which one's a 1939 Morris Minor and a 1948? I wouldn't know either. Let's hope that Google's provided us with an accurate picture as well. But here we have an individual selling his mother's car to a car dealer. He's selling it second hand, and the mother believed that the car was actually a 1948 model. And the logbooks suggested this as well. Turns out that the car that they'd sold the second-hand dealer was actually not a 1948 model, but in fact a 1939 model. Wasn't worth as much. Now, the car dealer's trying to say, well, the statement in the documents that the car was a 1948 model is a term of the contract. Because the sun's gone in there and represented. It's a 1948 model. And what the courts held are actually, even though the statement's quite important, it was a mere representation, as the son that's selling this car didn't have any expertise in the areas of cars to identify the difference. And the other thing you can tell there is that the parties can see the car physically. So they're selling what's in front of them. So the year in the court's eyes wasn't as big of a deal. But the other thing is the car dealer owed that onus on themselves because they had the expertise in cars. They should have checked it out before purchasing it. So we can see it is the representation was a correct representation according to the fact that the son believed. They all thought it was in 1948. The statement was never reduced in writing. And Williams, the son, had little skill or knowledge in relation to automobiles or cars. So all that weighs together to suggest that it wasn't a term. More expertise, more likely to be a term. Now let's think about someone selling a business. And they give representations about what that business does or can get. Should be a good hint. Are they more likely to have expertise on what that business is about? And what does that mean for representation versus terms? Oscar Chess, know the case. Use it. Use it wisely. Another one is Ratledge and McKay. And this is a case where they actually reduced this into writing. And the document stated that the bike was a 1942 model. But in the written contract, which was signed, there was no reference to the model there. Bike was in fact a 1936 model. And the court held that because it was a verbal statement outside of the written agreement, that the statement was a representation and not a contractual term. That should be ringing bells as well, if you've read the research assignment. Here we didn't have any party that was an expert. And there was a little bit of time between the statement and the contract being entered, so there was an opportunity to check. There's no mention of this date. So what we say is when the contract is put into writing, so if you've got verbal statements before a contract being reduced to writing, those statements will generally be representations. Do those cases make sense? I've just gone through it really quick. But you'll have in your research assignment representations or terms, and your job is to apply these cases in concluding whether they are binding or not, and what that means for the parties. Express and implied terms. So these are the types of terms that you can have. Express terms you can see or read or hear. There's specific terms that the parties include. On the contrary to that, you can also have implied terms. Implied terms are notoriously hard to identify because they're not there. They're just imported into the contract, either through legislation. So, example, consumer law. And we'll talk about consumer law because it's an interesting topic. But also employment law. There's minimum protections afforded into employment law contracts, such as you'll get paid. It's implied. You will do the work. Even if it's not written in there, it's implied. We also have implied terms where customary use in that industry is there. And courts will also add implied terms for efficacy, so to ensure the contract is able to be performed. Note that the courts are very reluctant to add terms into contracts or to imply terms unless they really, really have to, because of the principle of freedom to contract. So if they didn't put it in there, then maybe it wasn't intended to be in there. But if the contract is unable to operate without that term, that's when they'll start to imply them in. Let's say you're at a restaurant and you purchase a meal. Your conversation is, I will order this particular meal. You generally don't at that time talk about the price of the meal or that you'll pay for the meal. But there's an implied, reasonably implied that you will pay for it by the transaction itself. So implied terms will only be put in there if they're reasonable and equitable. So they have to be fair to both parties, and they cannot impose an unreasonable burden or detriment on either or either. This is a barrier to it, so they don't really just put them in. It has to be necessary to give the contract business efficacy or the ability to operate, and it must be so obvious that it goes without saying. And we've got Summers and Commonwealth as a bit of a case for industry practice. And in this case, Summers was selling marble to the Commonwealth. And the contract specifically said that the marble should be to a certain specification, so to a certain block size. But Summers argued, and he supplied, marbles that were bigger than the specification because it was industry practice. So you provide some additional marble blocks that weren't to the right size so that the labourers could cut it down to a particular size as required. So had the contract not have said anything about the specification, the courts would have implied that industry norm. Yeah, because it's what they generally do, so you can resize it. But because the contract was express on it, he had to supply it to the specification. You can see if you had a different fact pattern, you could use the industry practice. Important thing is that the implied term cannot contradict any express terms of the contract. That goes without saying. So a case for business efficacy, we have the Moorcock in 1886. This is a ship that was moored in a wharf maintained on the River Thames. And the ship's been wharfed there, or parked there I guess you can say. And what's happened is the tide has gone out on the River Thames. And as the tide's gone out, the boat has sunk to the riverbed. And because of the water rushing at the time, the riverbed had exposed rocks and the boat was damaged when it went down. So there was no provisions in the contract around the riverbed being safe. But what the courts held though, that there's an implied term that when you allow these boats to enter these agreements with you, there's an implied term that that place of parking would be safe. Because without that, there'd be no business efficacy. There'd be no reason to enter that agreement. So what it does is it maintains the intentions of the parties. That being, exchange of money for a safe place to park a boat that looks like a sailboat. We're going to get into the exciting stuff now because terms aren't that much fun, let's be honest. Any questions around that so far? Now we're getting into things that actually matter to you guys, consumer goods. So legislation imports minimum guarantees into all contracts, whether they're written in the contract or not. So let's say you buy a laptop and you're going to Apple and you buy a laptop for $5,000. You buy the best specs, 16 gigabyte dedicated RAM, I don't know, graphics cards. You go all out. You take that computer home and it doesn't work. For some reason it just doesn't work. You go back and you read the contract and they've given you the extended warranty for 2 years. You've paid for it. And there's nothing to do with the faults in there. Let's just, as a hypothetical. Or they say that there's no returns. Don't ever believe a shop that tells you there's no returns because you've got rights under consumer law. So the computer's defective, you read in the contract, but legislation, the Australian consumer law, provides minimum protections that then get implied into the contract. So even if it's a controversy to the written contract. So then you can take it back to Apple and get a refund or a replacement. One thing is that you can't contract out of these guarantees. That's what I mean by no returns policies. There are minimum protections that overcome that. Same with warranty documents. Let's say you've bought a car from a new car dealer and you know you get those 5-year warranties. You have to, maybe it's a 7-year, 350,000 kilometre or something like that. But in the terms and conditions of those warranties, they will require you to take it back to them to be serviced every 10,000 kilometres. And if you don't take it back, you void your warranty. Noting that you can go to other service places. They tried that in terms of if you bought a Ford, you had to get it serviced at Ford. They can't uphold that. You can get it serviced at any registered mechanic. But let's say you miss a service. You missed the first one somehow. And then 40,000, 50,000 kilometres, your clutch breaks. Maybe you got the Ford Focus, dual clutch. Anyone bought one of them in the last 2012 to 2015? That dual clutch is very problematic, slips, and there's a class action at the moment for consumer guarantees now. But even though you're in breach of the warranty document, if you can prove that the car was defective, and that's what they're trying to do in this case, showing that the clutch is defective and Ford knew about it, then the warranty goes out the window in terms of Ford can't rely on your breach of it, and they have to rectify the issue. Seen a lot in mobile phones too. Who's had water damage? Water damage and you've gone to take it back. They tell you, no, we don't cover water damage. And then you say, well actually, do you consider humidity to be water damage? And unfortunately this time they said yes, unfortunately for the mobile phone company. And the problem there is, what is the purpose of a mobile phone? It's to be in your pocket, mobile, taken places. Where's there a lot of humidity? Queensland. So if the phone's not fit for the purpose for what it's designed, that's being mobile, so you can call, then they're in breach of a consumer guarantee. And they can't then say, well, it's water damage, we're not rectifying it. So what does the Australian consumer law imply? Firstly, that the person selling you the goods owns those goods. That means that when you purchase it, someone's not going to come after you and say, well, that's mine. So that's implied. You also have undisturbed possession and that there's going to be no securities over it. What's important though is section 54 to 56. There's a guarantee that the goods will be of an acceptable quality. That means that they will work, they will operate, the computer will turn on and do its functions. So you buy a suit pant and you notice that the leg, no stitching. You can then take it back to Oxford and say this is not of an acceptable quality, not merchantable, because pants should be all in one piece. So even though Oxford have a no returns policy, and they'll try and fight you on it, they're required under law to fix it. And that could be repairing it, refunding it, or replacing it. So never accept the no returns.
Well, that when they say you can't exchange if you change your mind, is that covered under consumer law? Because like, I worked in retail for years, years ago, and people used to come in and say like, oh, I just changed my mind, or I actually worked at a news agency and people used to try and return newspapers and stuff like that in magazines. So I was wondering what the sort of rules around that were.
Okay, so change of mind is not captured by a consumer guarantee. So stores are protected from me going in going, oh, I like this suit, walking out with it, coming back the next day and saying, you know what, that looked terrible on me, you can take it back. They won't give you a refund. They might give you a refund if they're a business that's inclined, but they don't have to under consumer law. That is unless the goods don't correspond with their description. So maybe I've purchased the suit and they've said it's a size 28 and in fact it's a size 32. I can take it back then because it's not matching the description that they said. Vice versa, you might be buying a maple drum kit. The website says that it's pure maple, but you receive it and it's made out of mahogany. It's not matching the description of its advertisement. So under consumer law, you should be able to get a replacement refund. The other one is the goods must be fit for a disclosed purpose. So this can be implied. So the mobile phone, it's implied that it should be portable and you should be able to make calls. But you may also explain a specific purpose that you'll be using that good in your transaction. Say for example, you're buying that laptop, you bought the 16 gigabytes dedicated RAM to play games. And you get home and it just can't play games. You've told the salesperson that you want it to play, I don't know, PUBG or whatever everyone's playing now. Get home, it doesn't work. You can then take it back because it was not fit for a disclosed purpose. You physically said what it's for. Same with running shoes. Maybe you've disclosed that you need it for a certain foot type. You've got a bunion or something like that. And the shoe doesn't fit that purpose of protecting that bunion. You can take it back. 57, the goods must correspond with any sample. You know when you pick up a tile, maybe from Bunnings, or a carpet swatch, or even a paint swatch? If then you go back and order the rest of the carpet, and you find out it's not of the same thread count or quality, that's what we mean by it's not corresponding with the sample. So you should be able to rectify that under consumer law. This one I find interesting, section 58. And that's the manufacturer must ensure that repairs and spare parts are available for a reasonable amount of time. Apple. Think of straight away. What do they do to the laptops? What this means that if you get a product and it breaks, the manufacturer for a reasonable amount of time should be providing spare parts so you can fix it. And the reason for that is that they don't want situations where you're purchasing something and it constantly breaks and you have to purchase the whole new product again. So they need to be able to provide materials for you to fix it. And lastly, they have to comply with any express warranties that they give in their goods. So there's those contracts. Just as they apply to goods, they also apply to services. So there's a guarantee that services provided by someone installing light fixtures would be rendered with due care and skill. That they'll be fit for the disclosed purpose. And that they will be supplied within a reasonable time. So very similar to the product stuff, but we're relating to someone providing a physical service.
Doesn't the section T6 that it should correspond with its description, doesn't that contradict the rule of misrepresentation?
So the goods must correspond with their description?
Yeah. Doesn't it contradict to misrepresentation, which you can't really sue for?
It's a good point. So does it contradict the rule of misrepresentation? One thing we need to remember is that legislation trumps common law. So if we're looking at a legislative provision, you can say that it will always take over from misrepresentation. What's important to note though is consumer guarantees only apply to consumer goods, not houses or fixtures that are on the ground. And we'll explain what a consumer good is. One thing though, misrepresentation is also a statutory provision under section 18. And we look at that next week, and I guess you can call it false and misleading representations. Has anyone bought Nurofen perhaps 3 years ago. You remember the targeted pain relief? Yeah, so you had Nurofen advertising different tablets, maybe for migraine pain, back pain. Yeah, all these different pains. And do you know what? They all had exactly the same ingredients. So that targeted pain was held to be false and misleading under misrepresentation. And they were fined $6 million for that, plus $3.5 million in compensation payments. So if you've purchased Nurofen targeted relief, you can go to Nurofen and get your money as compensation. But there is a statutory misrepresentation that we talk about next week. It's a good question. So we look at the guarantees, but what is a consumer good? So a consumer good is anything that you acquire that is less than 40,000. That's most things. Microwaves, computers, clothes, shoes. Some shoes might be above 40 grand, I'm not sure. But it doesn't matter if they're above 40,000 if they are a kind ordinarily acquired for personal, domestic or household use. So you've got a two-step test to start with. Is it 40,000? And if not, is it a product that's ordinarily acquired for personal, domestic or household consumption? The other test you need to satisfy, has it been acquired for resupply? So let's think about a baker who owns a bakery and they buy flour. Flour's under 40,000. And it's also something of a kind that you would purchase for a house anyway. So it satisfies the first part. But what the baker's doing is transferring that flour into something to sell. So it's been acquired for resupply. So that baker won't be protected by consumer guarantees. Maybe he ordered flour and he got self-raising flour and his pancakes are... But if it's carpet, and this is what we'll see in the example. I thought we'd see an example. If it's carpet, and we've got a case in Queensland between Carpet Call and Chan. Now Chan owned a nightclub in Queensland, and he's decided that he wants to recarpet the nightclub. He's purchased, I think, 90,000 odd, that's a rough amount, dollars of carpet, which exceeds the $40,000 limit. And the carpet wasn't up to scratch. It wasn't of an acceptable quality, or there was some other issue with the description. So he sued Carpet Call. And Carpet Call is saying, well, the consumer guarantees don't apply to you. One, it's more than 40,000, and you're using it in a business. But even though that was the case, the court held that carpet is a product of a kind ordinarily acquired for personal, domestic or household use. People install it in their houses. So it was still considered a consumer good that was subject to consumer guarantees. So what are the consequences for these companies for breaching the guarantees? The main thing is that you can request a remedy of the issue, as long as you do it within a reasonable time. So they can repair the goods, replace the goods, or they provide a refund. Generally, they'll have a choice themselves, so long as they remedy the issue. If it's a major failure, or something that cannot be remedied, so it can't be repaired, then they must provide you with a refund or a replacement. And let's take the Ford example, if it's successful. Now that you know that the 2013 Ford Focus has a clutch issue, how much are you willing to pay for it? The value of that car has already dropped, just by the fact that that's a known issue. So businesses where, if they can't remedy that failure, would be required to pay you the difference between the value that the Ford Focus would be at without the issue versus the Ford Focus with the issue. That might be $5,000, but that's an example of a compensation payment. Also know that you may be able to go after the manufacturer. Generally, we go after the person selling it to us. So the Ford dealer that sold it to you, but Ford actually manufactured it. They're different businesses, believe it or not. Which makes it challenging. Any questions about consumer guarantees? So we talk about consumer guarantees, and then next week we'll look at the other consumer law stuff, such as misleading and deceptive conduct, unconscionable conduct under statute, and those type of things.